Good morning. Thank you for joining our live webinar, live Q&A, where you can pose your questions beforehand and I'll try my best to answer it. As you know that quite a few people have posed quite a few questions via our various platforms. We have tried to update our system a bit more better. So below me you'll see some scrolling where you may pose questions in the future regarding child custody, child maintenance, relocation, consent issues, adoption, surrogacy, abortion. All those questions are all form part of family law, and I obviously will try my best to answer it for you. So remember, there are three ways of doing so. Number one is you can interact now via Zoom. Um, the link below, the scrolling below, you will find the necessary link. Automatically you will receive a Zoom link and you can interact with me now, or you can pose a question before the time by registering it, and obviously it will be sent to us. We will email you the day before when we'll be dealing with those specific questions. And at the same time you can make use of Facebook Live, whereby you can interact with us via that specific platform. I'll obviously keep my eye on Facebook Live as well, so if you are watching this video via Facebook Live at present, feel free to pose your question there and I shall interact with you. Okay, we have somebody on Zoom who has registered and willing and wanting to interact with me. Great. I'm happy to hear that and see that. So hopefully we can have some great interaction. That specific person is the person that posed question 1. Okay, question 1 from Gauteng. It's typical scenario which I deal with or I hear about quite often, whereby the maintenance officers, they do not deal with maintenance matters in the manner which they should, in terms of the Constitution, South African law, the Children's Act, and various legal pieces of legislation. Obviously, when it comes to matters concerning a child, the maintenance officer and the maintenance magistrate, they have a legal obligation to ensure that the child's best interest is upheld. That it is a constitutional imperative, and therefore it's not for them just to try to dispense with maintenance matters as quick as possible, acting as judges, acting as magistrates, and not giving the rights of the claimant to them. That's very important to note. There's a legal obligation on all magistrates, on all maintenance officers, on all maintenance clerks to make sure that when a maintenance matter is being resolved in front of them, that due regard is given to all the necessary tools that the Maintenance Act has provided for them to make use of. That's very important. And it quite often happens, and this is my problem. It quite often happens where people approach a maintenance court. There are a lot of people in the queues, in the aisles, and the maintenance officers just dispenses with these matters ASAP, quick as possible. They do not give it proper due regard. And it's very important that if one party, for example, let's say the party that has to pay the child maintenance, does not come to the maintenance court with the necessary documentation, with the necessary information, and so on, the maintenance officer must not dispense with this matter until it has determined that all information is before it. And once it has done that, the same applies to the mother and the father, both of them. All information is before it to determine whether or not a fair maintenance amount would be made, a maintenance order would be made. And until only then can the matter be dispensed with. It is not for the maintenance officer to say, you know what, in our area, we only give maintenance of 1,000 rand per month because that's generally what we receive, despite how rich the father is or how poor the mother is, and vice versa. That is amount, which is obviously nonsense. Every maintenance matter must be dealt with on its own merits and on the facts and information before it. Full stop. In a very poor area somewhere in South Africa, an amount of maintenance of 50 rand might be a reasonable amount considering the circumstances. But in that same court, if there is a wealthy person living there and a wealthy family living there, and the maintenance amount must be 50,000 rand per month, the maintenance court must make that order. And the same amount of effort that the maintenance court made in resolving a matter where the parents are wealthy and the children require a lot of money, the same amount of effort the court made in that specific case, the court would have to make in the specific case where the children, where the families are not as wealthy and are not as affluent. So I hope I've explained to you the role of the maintenance court. And if you are a maintenance officer and a maintenance magistrate watching this video, please make sure that your constitutional directive is being implemented. I mean, I done an appeal matter about 2 years ago in Grahamstown, and the judgment in the matter specifically outlined said, I mean, the courts have a legal obligation to do their jobs. It's not to, deal with maintenance matters as a, conveyor belt. Let's dispense with it quickly. They have to do their job. Okay, the question from Gauteng, question number 1, and thank you for waiting for me on Zoom. I will let you in the next few moments' time. Basically, it is a problem which the mother has. There is a maintenance order in place. She's going to the maintenance court on and off all the time. And the maintenance officer in this specific case, in my view, would have obviously tried to have this matter resolved as quick as possible. And the maintenance officer made certain, very improper decisions and advices to the complainant. So I've highlighted a few a few points, and which will obviously deal with, and the questioner can obviously deal with it a bit better now. What are the procedures to dispute a maintenance because I'm not happy with the maintenance officer ruling? I want to take the matter back to court for a formal inquiry in front of the magistrate. Firstly, a maintenance officer cannot make a ruling. He is not a judge, he's not a magistrate. But it seems to me some maintenance officers think they are that. So the maintenance magistrate would have most probably made the order, but the maintenance officer would have been the person that has obviously most probably tried to, push that this file be resolved sooner than later. Okay, I've highlighted the further points. I want to dispute the order because the officer was biased. The officer told me that I can't claim accommodation because it's my bond, so it's my problem. That is nonsense. If you have a bond, if you're paying a bond, the other party has no obligation to pay your bond. That's very important to note, but the other party has an obligation to pay towards the child's living expenditure, the child's accommodation. So your bond might be, I'm using a silly figure here, it might be 1,000 rand per month. Now you have to work this out. If you had to rent accommodation, right, and the accommodation would most probably be another silly figure, 500 rand per month. And the child's portion would have most probably 200 rand, because had you not have the child, you would have most probably rented 300 rand, paid 300 rand per month for the accommodation. That portion of 200 rand per month, that portion is the child's portion towards the accommodation. And the other party has to contribute towards that specific portion. So your bond might be 1,000 rand per month. You cannot ask the other party to contribute towards the 1,000, but you can ask the other party to contribute towards the 200 rand per month, because that would have been what it would have cost the child to live in any event. Okay. So then the person goes further and deals with various other issues and problems. But then it concludes, I want the court to look at this. Please advise me, frustrated mother. Okay, Mom, I will allow you to join via Zoom, and you can just comment a bit further or interact with me a bit further, and we can take it from there. Are you online?
Yes, I'm still online.
Okay, wonderful, yes. Do I have the gist of your question? Do you want to add anything else before I go further and try to give you some advice regarding this?
Looking at our income, expenditures, and child needs, and other things were cut out of my play. That's my challenge. That's why I wanted to
Sorry, for some other reason, the sound is not coming so well through that. Okay, so I think we're having some technical difficulties with getting the zoom into the specific question over here. Okay, but nonetheless, let me deal with that question holistically, what you can do. I think that is what ultimately what you want to know, what you can do in the specific scenario. I think that's very important to note. So let me deal with that quickly. Let me just obviously there is a maintenance order in place, right, which a mother is not happy with. The challenge you have is, the question is, are you going to appeal that specific magistrate's decision? Because the magistrate made the order based upon, obviously, and I'm looking in between the lines here, it should have either be done via an agreement, or the maintenance officer asks you, ma'am, are you happy with this? And you, of course, would have said yes, and they made an order. If you said, I am not happy with a specific recommendation of the maintenance officer, the matter would have proceeded obviously to a trial, where the magistrate would have obviously called the mother as a witness, and she can testify as to the expenditure of the child, and they would have called the father, and he would have obviously have done his thing and explained why he cannot afford it or what he can afford and so on. But that did not take place. So the question is, can I appeal the specific decision? Now, my view on the specific matter, appeal must probably be very exhaustive, because the court file might be empty. And if you are going to appeal the specific decision, what would the appeal court have before it in trying to come to some type of an answer whether or not the maintenance officer made a proper decision or not? So I would most probably say, do not appeal this decision, and there might be some documents stipulating that you actually agreed and you accepted the amount offered by the father. I do not know when this application was, obviously the order was made, but it doesn't seem to be too recent. I would actually approach the maintenance court again and advise them that these are the current income, my income, and these are the expenditures of the child. It is far too little. I cannot survive from this specific amount of money that is being paid to me as child maintenance from the father. And I would like to have the current order, re-looked at. Number one, firstly, because it is too little. And number two, the father can afford much more money, but an inquiry needs to take place to confirm that. So basically, we're asking the court to deal with this matter afresh, but properly. Firstly, factually, you cannot afford to survive off the amount of maintenance being paid. And secondly, a proper inquiry did not take place in looking into the father's circumstances. And you are fully of the view that the father can afford the amount of maintenance being claimed. Are we on the same page with that is concerned? You're welcome to comment if you can get through.
Yes, I'm on.
Okay, so that will be my advice to you. Go back to the maintenance court and say the father can afford this amount, and the amount currently being paid is too little, and do that as soon as possible. When was a court order made, if I may ask?
On the last, yes, thanks. Okay, then what is the substitution or the discharge?
Sorry. The question now was, my apologies for that. The question was, is it an application for substitution or discharge? Um, the answer to that would be that it would be an application for a substitution of the order. So you changing the order for a new order. So the current order is most probably X amount of rands per month, and he should pay for the following. You're asking the court now for an order to be substituted with that order for a higher amount of money, and for him to pay other things as well. A discharge application would basically mean that there's no need for a maintenance order. as mentioned earlier on, and I think it didn't appear that where the father will apply should the minor child be maybe 18 years old and self-supporting, or the father lost his job completely and is unable to pay the child maintenance, then he will apply for discharge. So discharge, order falls away, substitution, we're putting in a new order in his place. So that basically deals with that. So hope, wonderful, thank you for that interaction. Okay, but I'll chat to you a bit later afterwards on Zoom, and maybe we can have some video chat where that is concerned. Okay, let me get to question number two. Question number two, quite a interesting question. My maintenance file spans from December 2010, which is quite standard these days. Very, very sad that people have to fight for maintenance for 11 years. Okay, she tried to get hold of the father, subpoenaed X, Y, and Z. He moves from one court to another court. What I have highlighted was I have 3 children who have suffered through this, and I'm needing to ask, is there any hope? And the last question would be, at the end of that question was, not sure where to turn to or how to begin again. Okay, the difficulty which I have in sometimes advising clients from a distance, where I'm sitting here from in my office, or I can call it an armchair. I do not know what difficulties you have gone through, what you have done, the challenges you have endured, the other party, his attitude, what he's done, the maintenance core dynamics, and all those things. I'm sitting from an armchair from a distance away. It's like someone playing a football match. It's easy for me just to talk here and give you the advice on how to win that match, but I'm not there. I need to be in the mix and in the battle in order for you to fight for it, because it's impossible for me to advise you what move to do unless I am there dealing with the matter. So when I'm dealing with the matter, I can obviously apply my mind to it and say, okay, this might work, that might not work. Test it. Okay, did not work. Let me try this, and going forward. The bottom line is the maintenance courts have an obligation to assist parents in obtaining child maintenance. If the other party has an attitude, sorry about that, if the other parent has an attitude in the sense of I will not pay maintenance, I do not want to pay maintenance, I'm going to make it very hard for the other party to obtain maintenance from me. That is the attitude. And that person makes it very difficult. So in the specific example, the person works as a consultant, the specific person hides money away, only a little money comes to his bank account, and that money which goes into his bank account, he or she shows to the maintenance court. Let's say, for example, 10,000 then comes to his bank account for his business, but 100,000 goes through cash deals, or via different bank accounts that we do not know of, that we do not have any access to, or any knowledge of. So that becomes very difficult. And I find it very sad that we have people out there like that. I have no problem with a father or a mother who has to pay maintenance and says, I do not think it's fair for me to pay for the X, Y, and Z. That is fine. Let us debate it, let us discuss it, and let us come to a decision. But he puts everything on the table, or she puts everything on the table. His income, his expenditure, and also the mother has to do all of that. She has to explain what her income is and what the expenditure of the children are, etc. And we can debate it and we can argue it and we can say, okay, no, you want to pay 1,000 rand, we want 1,300 rand, let us meet in the middle, let us resolve it. But I have major problems with people who know the child costs 1,000 rand per month, in my example here. But he or she will make it sure that they only pay 50 rand maintenance, despite them earning 30,000 rand per month. They'll make sure my mission in life is to pay as little maintenance for my child as possible. I will go to the ends of this earth, pay lawyers, do whatever I can do, earn maybe less money even. They'll do that. Because they'll say, if I earn more money, I must pay more maintenance. Therefore, I will not get a promotion at work. I will earn much more. I will earn much less money in order for me to pay less maintenance. And that is very, very sad. And you have that out there. You have people like that. So those are the parents from the other side, the father or the mother, that I have very I find it very difficult to advise you when it comes to those specific parents, because they are not playing the game fairly. Their mission in life is not to pay. The other parent, on the other hand, is someone, as I mentioned earlier on, he outlines his income and expenditure fairly, his salary, and there's a debate and discussion as to what is reasonable or not. That is fine, I have no problem with that, because what's reasonable to the mother might not be reasonable to the father, and vice versa. So my advice to you for the specific questioner from Gauteng is relook at the entire matter. Analyze it from a point of view. You know this father, what his ways are, what he does, how he hides his money away. What is his modus operandi? How does he operate? That's very important. But at the same time, ensure that your specific case is foolproof. You have full details of your income, your expenditure, the children's expenditure, the children's needs, and so on. And then approach a maintenance court from that specific angle, from that specific attitude, and make sure that the maintenance courts assist you. If it means going to the maintenance officer's manager, going to the court manager, doing whatever you need to do, make sure the maintenance court makes it possible and makes it happen that you obtain the maintenance you're entitled to. In all honesty, and I'll be honest with you watching this video, and if you're a maintenance officer, magistrate, clerk of the court, whoever you are, the tools that are afforded to you in terms of the Maintenance Act, the old Maintenance Act, the amendments of the Maintenance Act that came in a few years ago, if you use all those tools, and you're getting paid for that, you're getting a salary for that, if you use all those tools, every party who has to pay maintenance, who's trying to hide from the system, will be brought to task if you use those specific tools. But the sad thing is they are not using those tools. So my advice to you is, the questioner from Gauteng over here, I do not have a one answer, do this, do that, that will fix everything. I'm saying there is hope. Make sure your documentation are in order, go to the maintenance court and make a noise. And until the maintenance officer does his or her job, you do not leave the offices. They are maintenance investigators. People can investigate you. The Act allows that. Many people believe that they are only maintenance officers. They are maintenance investigators. They can subpoena people. They can go to the banks. They can get data for you to assist you in obtaining your maintenance. I hope that assists you where this is concerned. If you look at the scenario, you will see the word garnish your orders. You see various things that the specific party done. But the bottom line over here is we need to show the other party that you mean business, and the maintenance court must assist you in doing that business. Sorry about that. Okay, question number 3. Interesting question. Am I entitled to claim back maintenance? Okay, so let us just get the screen right. Okay, am I entitled to claim back maintenance? So there are two scenarios that may be of application. Number one would be there is no maintenance order in place. Let us say the mother and the father live together. The child is 5 years old when they separated. The child is now 6 years old, and the father never paid any maintenance for the last year of the child's life. Now the question might be, can I claim back maintenance? Can I claim maintenance from when I left the father until now? That's the one scenario, and I'm using simple figures here. There might be legal terms to refer to that. The other scenario would be, can I claim maintenance that the party has not paid the maintenance in terms of a maintenance order? So there's a maintenance order in place. You've done nothing for an entire year. The party was ordered to pay 1,000 in maintenance. You've done nothing for an entire year. Can you still claim that maintenance going back? Okay, so let's deal with the first scenario. Yes, it is possible for you to approach a maintenance court if the other party has not maintained the child despite there not being any maintenance order. So in my scenario, you can approach a maintenance court and tell the maintenance court, you know what, I separated from the father of the minor child a year ago. He has not maintained the minor child for the last year. I would like to get money from him for the last year because it cost me 1,500 per month to look after the child for the last 12 months. I would like him to pay half of that 750 per month, and at the same time I would like him to continue paying the 750 per month going forward, plus inflation plus CPI or 10% increase every year and so on. That is possible. So the question is, am I entitled to claim back maintenance? Yes, you are. You're allowed to claim it. The court will obviously come to a decision as to what would be a fair and proper amount. Okay, Regarding should someone not pay maintenance in terms of a court order, my fictitious scenario, which I am putting out there, yes, a maintenance order remains valid, and the maintenance amounts owing in terms of that order remains valid indefinitely. Therefore, if someone has not paid maintenance for the last year, you can approach a maintenance court, and the maintenance court can obviously attach his salary, attach money from him, go into his bank account and take money from that, etc. And it is a criminal offence not to pay maintenance as well in terms of a court order. Okay, I think that deals with that specific question. Question number 3. Question number 4. Okay, interesting one, and I put it on for the sake of doing this. I do not require legal advice. I want to attend this session as I intend to proceed with pupillage in the near future. And this is one of the facets that I have a keen interest in. I would like the opportunity to attend this session to gain more knowledge on the topic and to understand how to handle problems of this nature. Okay, that's wonderful. Pupillage meaning somebody who has a law degree and would like to become an advocate. So that's great. You're welcome. Thank you for your comment. And I hope you'll become a very good advocate one day. Question number 5. Okay, another long question, and obviously something I would like to assist you with. So this specific person has twins turning 15 this month. Okay. The father had been paying 2,500 maintenance for the last 3 years and 1 school fees and helpless school clothes for the 1 child. He's supposed to buy them clothing for when he has them for on holidays and so on. So the mother cannot afford to pay for the school clothing, and she's sending the kids on holiday to him, and hopefully he will pay for that. The children are supposed to be on her medical aid, but he did not. On his medical aid, but he did not do that, and now the children are on her medical aid because of work. The work is allowing that. Okay, what I have highlighted further was, I have asked him to increase it, and I'm not asking for a ridiculous amount of money, but he hasn't budged. And she goes further, the girls have needs, and I feel he needs to play a bigger financial role. He is remarried and has 2 children. Beginning of this year, he started working overseas. He comes back 3 months and goes back. This is a question. I want to know if he isn't in the country, could his wife be subpoenaed to court on his behalf? So that's basically the question. The person is complaining about him not doing what he's supposed to do. So let us deal with that first. As I mentioned earlier on, if someone is not adhering to a maintenance order, you have a right to enforce that order either criminally. The maintenance court would advise you, of course, what's the best channel, either by the criminal courts, and if they find him guilty, you could possibly go to jail, or by the civil route where they can attach his property, get a garnish order, get his boss to pay the arrears, and so on. So that's the options which you have. So go to the maintenance court as soon as possible. If you want him to pay more and he's now saying he's not budging, he doesn't want to, you may still approach a maintenance court and ask the maintenance court for an order for the substitution of this order with a greater amount and so on. So those are the options which you have where the maintenance court is concerned. Regarding your legal question, which is, I want to know if he isn't in the country, could his wife be subpoenaed to court on his behalf? The answer is no. There is no legal obligation on step-parents to maintain stepchildren. There is no legal obligation. Tomorrow the parties might divorce again, and then does the maintenance order still remain intact? Let's say, for argument's sake, to explain the scenario, let's say, for example, that was possible. The father marries another lady, she's very wealthy, and you take her to the maintenance court. The court makes an order that she should pay the stepchildren 1,000 rand per month. Tomorrow they divorce. Must she continue paying the 1,000 rand per month? She's no longer married to the husband. So there is no legal obligation upon step-parents to maintain stepchildren. It's very important to note. But what is interesting, and which you have to apply your mind to it, and maybe hopefully you'll figure this one out, is that if the father got married to a lady and they were married to each other in community of property, then there is now one estate, a joint estate, then that specific estate would be responsible for the child maintenance. So if the father earns very little money, apologies, if the father earns very little money, but his new wife earns a lot of money, that goes into the joint estate each month, and then that specific money can be used to pay the child maintenance of the children. And in her regard, her stepchildren, and his regard, his children. So that's why it's very important to know how the parties are married. Are they married in community property, whereby the joint estate can be responsible to pay the maintenance of the children, or are they married out of community property, whereby what belongs to the father belongs to the father, what belongs to his new wife belongs to her. And under those circumstances, you cannot get any money from the new wife to pay for the father's children's maintenance. The new wife, of course, has an obligation to maintain her husband. Okay, I hope that answered that specific question. So my advice to you, as I mentioned earlier on, go to the maintenance court and ask them to assist you with that. Okay, question number 6 from Gauteng. We're having a lot of questions from Gauteng, and I think, yeah, a lot of questions from Gauteng. Western Cape, please join in this. I think we have a few questions from Western Cape that I will be dealing with tomorrow. Remember, tomorrow's webinar is 12 o'clock and not 11 o'clock. Question number 6. I have a maintenance case. We attend our first date. Then the father said he needs a DNA test to make sure that the kids are his. The DNA test date was the 26th of October. That was the last month. Then the mother went to court. I found this guy sent a doctor's letter to say that he's tested COVID positive. Okay? But it comes to sign our OB book. The maintenance court is going to help me. So I do not reword these questions. I post them as they are, unless someone spelled the word maintenance wrong or court, and I change those specific things. But nonetheless, so here the father is saying, okay, I'm not the father, I'm not sure I'm the father. What happens then in a maintenance court? So we'll unpack this specific scenario. Remember, you are only obliged to maintain your own children. You're not obliged to maintain someone else's children. That's very important to note, and I think we all understand that specific concept. We're not obliged to maintain someone that's not relative to you. Therefore, if this father is not the father of the minor child, how can we proceed with a maintenance inquiry for him to pay maintenance towards his minor child if that specific issue is not being finalized? It doesn't make logical sense. I mean, you can have a problem whereby a mother can intentionally, not saying my scenario, this example is obviously a legitimate scenario, but you can have a problem where a mother can say, oh, that guy is very wealthy over there, a lot of money. Let me approach a maintenance court and tell the maintenance court he is the father of the child. Yes, I met him once, so you can't dispute that. There's a few photographs on Facebook about with us together. So, you know, I can bring up an argument that I am the father of the child, so that he is the father of the child. And then that's it. Then she has a wealthy father to look after the child, despite her knowing who the other father is, who the real father is, and he's not as wealthy. Therefore, the DNA test needs to take place. Once paternity has been confirmed, of course, then the matter proceeds as usual. Therefore, I do not, obviously we're dealing with COVID-19 here, and if the father has been excused because of a doctor's note stipulating that he is COVID-19, unfortunately we have to now wait for that specific few X amount of days. Those days changes so often. But let's say you have to wait those 2 weeks for the finalization of the specific issue regarding the COVID test. And once the COVID test is once the paternity issue is finalized and he is confirmed to be the biological father, remember, you're welcome to ask the maintenance court for maintenance order to be backdated, in lay terms, from the date when the father stopped paying maintenance, or he did not pay maintenance, or the date of the birth of the child, whatever the case may be. So the delay because of COVID-19 and the paternity does, unfortunately, it is inconvenient to you. You need the money, but it does not mean that you will not get the money which you have expended for the minor child. Okay, I think we've done well today. Those are the 6 questions, and I think we dealt with it quite in depth. There's quite a few questions that were posed. If you have a question, yes, sometimes, and I think it seems to me it's about 10 or 15 questions gets posed at a time. Sometimes just comments, but please pose your questions using the various platforms mentioned below me, a bit further below this window. And I would like you to interact with us via Zoom. I think we had a technical problem regarding Zoom. We'll try to fix it by tomorrow with the IT department. But nonetheless, thank you for joining this webinar, and I hope to see you online again soon. Tomorrow is 12 o'clock. Have a lovely day.